Today, my group will like to talk about Companies Act 2016. The first section of Companies Act 2016 is Section 261, Auditor's Statement. Auditor's Statement has 2 points, which are: the first point is the company is not required by this act to lodge financially statements with the registrar, shall lodge with the registrar a statement relating to the financial statements of a company required to be circulated to its members. For example, like the first one is stating whether the company has its opinion keep proper accounting records and other books during the period covered by those accounts, or stating whether the financial statement has been audited in accordance with this act. The second point is the company and every officer who contravene this section commit an offense and shall be conviction be liable to be fined not exceeding 20,000 ringgit, and in this case of continuing offense to the further fine not exceeding 1,000 ringgit for each day during which the offense continue after conviction.
Next is qualification of a company's auditor according to Section 263, Section 263. It says the person can apply to the minister to be approved to become the company's auditor. The second one is if the minister satisfied with the person's or applicant's characteristic, the person will be appointed as a company auditor. The third one is the approval can be revoked by the minister at any time if the person is not fit after the approval. What does revoke mean? Revoke means override, like reset or default. How do they revoke it? Well, they revoke it by the service of a notice of revocation. The fourth one is renewal of approval only made for 2 years unless revoke is created earlier or sooner. The last one is if someone is not happy with the minister's decision, they can appeal to the court so the new auditors will be appointed. Next is disqualification of a company's auditor according to Section 264, Section 264. Section 264 is about disqualification. Now, why the person is disqualified? Well, he is unpurposely agree upon appointment as an auditor of the company. The second one is unpurposely act as an auditor of a company. The third one is his spouse or himself is the officer of the company. The fourth one is a partner or a friend to the officer of the company. The fifth one is he is still declared bankrupt within or outside Malaysia. The last one is he has been convicted to fraud or dishonesty with imprisonment period more than 3 months. Convicted means committed. And that's all.
After my teammate explains of the qualification and the disqualification of a company auditors, next I would like to explain about Section 226, which is the duties of auditors. Duties of auditors have 3 main points. The first main point is every auditor of a company shall report to the members of the financial statements, and the report shall be, in the case of a public company, laid before the company at its annual general meeting, or in the case of a private company, it's circulated to its member or laid before the company at the meetings of the members. The second main point is that an auditor shall, in a report under this section, state whether the financial statement and if the company is a holding company for which consolidated financial statements are prepared. the consolidated financial statements are its opinion properly drawn up, so as to give a true and fair view of the matters required by Section 248 to be dealt with the financial statement and the company's affair. Thus, in accordance with the applicable approved accounting standards, or in the case where the financial statements are required to be prepared for or lodged with the authorities referred to the Section 26D of the Financial Reporting Act 1997. There are three main points, which is an auditor of a company shall have a duty to form an opinion to each of the following matters. The first one is whether obtain all the information and explanation that he required, or whether proper accounting and other records, including registers, have been kept by the company as required by this act, or last but not least, whether the returns received from the branch offices of the company are adequate. Next is Section 226, Powers of an Auditors. There are three main points as well. The first main point is an auditor of a holding company for which consolidated financial statements are required to has a right of an access at all reasonable times to the accounting and other records, including registers of any subsidiary if necessary, and is entitled to require from any officer or auditor of any subsidiary included in the consolidated financial statements. The second main point is auditor's report shall be to attach to or endorse on the financial statement or consolidated financial statements, and shall, if any member so required, to be read before the companies in a general meeting, and shall be open for inspection by any member at reasonable time. Last but not least, the third main point is an auditor of a company or its agent authorized by him in writing is entitled to attend any general meeting of the company and to receive all the notice of and other communications relating to any general meeting, which a member is entitled to receive and to be heard at any general meeting which he attends on any part of the business of the meeting which concerns the auditor in his capacity as an auditor.
Section 267. Appointment of auditors in private company. There are two ways auditor appointed by the board of directors and the members of company. The board of directors should appoint auditor for a new company and to fill in the job vacancy. Members of company. Members of company appoint the auditor when next following year after first financial statement period to appoint. An auditor should be appointed by both board of directors and members of the company in accordance of law. Period appointing an auditor is before financial statement is lodged and after financial statement is lodged. If the company violates the section, is considered as breach of the law. Section 271. Appointment of auditors in public company. The board of directors should appoint auditor at any time before the first annual grand meeting and to fill in the job vacancy. Auditor that has been appointed should fill in the position until the final decision of the first annual grand meeting until next annual grand meeting. Members of company. An auditor should be appointed by the members of the company at annual grand meeting. When the board of directors failed to appoint auditor at annual grand meeting, and when the company failed to appoint auditor at annual grand meeting. Company who violate to the section is considered violating the law as well. Section 274, Fixing the auditor's remuneration. Remuneration appointed, fixed by members of company by ordinary resolution, by board fixed if not fixed by company, by registrar if not fixed by company. Remuneration inclusive of sums paid in respect of expenses and payment.
Resignation of auditor. To resign, the auditor must submit a notice of resignation to the company at its official address. The term of the notice of an auditor will come to the end after 21 days when the notice of resignation had been submitted, or from the date in the notice. Notice of resignation of auditor to the registrar. When the auditor is resigned, the company is sent a copy of notice to the registrar within 7 days from receiving the notice of resignation. The company and every officer who go against this section considered as committing an offense. Right of resigning auditor of a public company. The notice of resignation is to be attached with the statement of circumstances concerning the auditor resignation. The auditor may present the notice of resignation with the signed requisition that demand concerning his resignation is to be received and heard. The auditor may request the company circulate a statement in writing which is concerning the circumstances of the auditor resignation to its member. It is before the meeting hold on auditor requisition and before any general meeting at the audit terms of office expired or vacancy by the auditor resignation is filled in.
Section 276, Resolution to remove an auditor from the company. Number 1, members can remove the auditor from company by ordinary resolution and according to Section 277. Number 2 is company cannot deny the right to compensate for any damages to the auditor after the resolution of his termination. Number 3, auditor cannot be removed from the company until his term is expired. Section 277, Special notice required for resolution to remove an auditor from the company. Number 1, the company is to send a special notice to the registrar when received by the auditor. Number 2, auditor can make representation in writing within 7 days of receipt of special notice and request meeting to justify. The copy of the representation shall be given to every members. Number 3, if the copy is not sent out, auditor may require the representation to be read out at the meeting. And the last one, if the auditor was found out using this section for unnecessary publicity, the copy of representation will not be circulated or read out at the meeting.